So I think now I'll hand over to you, Jess. So thank you very much.
Thanks, Nita, and thanks, ACEVic, for the opportunity for Law Squared and myself to speak about some of the employment law changes that are happening this year. Let me share my screen and we can get started. Hopefully that works. Can everyone see the presentation slides? Perfect. Great. But before I start, I just wanted to acknowledge, I just have an acknowledgement of country. We acknowledge the traditional owners of country throughout Australia and their continuing connection to land, sea and community. We also acknowledge that sovereignty has never been ceded and coexists with the Crown's sovereignty today, that sovereignty comes from a different source to the sovereignty claimed by the Crown from the ancestral tie between the land and its people, but still means that the First Nations' inherent rights cannot be ignored. Always was, always will be Aboriginal land. We pay our respect to First Nations, their culture, and their elders past, present, and future. So in terms of the agenda today, we'll go through the objectives, some of the current landscape, what's changed, some of the risks and liabilities that arise, some other changes that happen the rest of 2024, some tips and tricks around some strategic recommendations, and then at the end, like Nina said, we'll have some questions that I can hopefully answer them for you. So objectives, there's three main ones. I want to provide a general overview of the recent changes in Australian employment law, to equip you with some of the knowledge that you should have or shouldn't do in regards to these changes, but also, I guess, a greater understanding of the risks and liabilities that can be mitigated if you understand these changes. So what's the current landscape? I guess one of the key areas of reform since the Albanese government has come into power has been these workplace changes. These proposed changes were tabled in the Fair Work Legislation Amendment Closing Loopholes Bill 2023 and now 2024. Some of them have already become law, and some of them will soon to become law. But there's a wide range of changes that have happened over the last year. And if we look at the types of claims that have been lodged in the Fair Work Commission, they're quite significant. The Fair Work Commission has released their annual report for the 2022-2023 financial year, and there was 11,012 unfair dismissal claims lodged, and 4,964 general protections claims lodged as well, which is a bit of a decrease from the previous year of 6,315. But what's, I guess, important in all of this is there are other claims that have been lodged, especially the anti-bullying claims. So there's 730 applications for anti-bullying stop orders, which were finalised in the 2022-2023 financial year. Along with that, we've seen an increase in workers' compensation claims, in particular mental health. So there's 130,195 workers' compensation claims that were filed across Australia, and 9.34% of those claims were actually work-related mental health injuries. So we've seen a significant increase in that. And WorkSafe Victoria recently said that they're on track to have 33% of all claims by 2030 as mental health claims, which is just quite significant. So I think psychological injuries and mental injury kind of includes a range of cognitive, emotional and behavioural symptoms that can really interfere with the worker's life and can significantly affect how they feel, they think, behave and interact with others. When you look at psychological injuries, they include disorders like depression, anxiety, even post-traumatic stress disorders. It's quite significant. And they're very different to a physical injury where it's pretty set and determined. You break a knee, you're out for, more than 3 months, or a back. But with a mental health injury, you're out for much longer, and you're potentially not back. So it's really serious for both the employee and for the employer. And while we're not going to speak in detail about how to deal with those types of claims, I think it's important to flag that these types of claims are on the rise, and that it can really result in lengthy absences from the workplace. So let's talk about some of the changes that have been locked in. A lot of these changes you might be familiar with already, but I think it's good for us to just go over it again for completeness. So the first change is the paid family domestic violence leave. So employers of businesses, small, medium and large, now have access to 10 days of paid family domestic and violence leave, which is kind of instituted in early to mid 2023, depending on how large the business was. So this also means that the leave entitlement that was previously put in place, which was that 5 days of unpaid family and domestic violence leave under the NES, has been repealed. Now you have those 10 days of paid family domestic violence leave. So what should organisations do? They should update their leave policy and also update their contracts to speak in relation to the domestic family and domestic violence leave. We've also got a free sample policy on our website, so I'm happy for you to download that. But just keep in mind that it isn't tailored to your organisation. So if you'd like a tailored policy, please let me know and we can arrange that. So the next part will be fixed term engagements. This is something that's been in the news for quite a while. As you might know, from the 6th of December 2023, there's new restrictions on the use of fixed term contracts for employees. These restrictions are there to prevent kind of the misuse of these fixed term contracts. So if we think about what a fixed term contract is, it's a contract of employment that has a specified end date. And fixed term contracts that do have an early termination clause are actually called maximum term contracts. So in this piece of legislation, both fixed term contracts and maximum term contracts are covered. So what do those restrictions mean? It means that employers can't enter into fixed term contracts with employees if the fixed term contract has a term for more than 2 years. So what that means is that the end date of the contract can't be more than 2 years from the date of the start of the contract. The contract contains an option to renew for another term that's overall more than the 2 years, so you can't do that either. And the last one is that the fixed term contract provides for an option or right to renew to extend more than once. So it's lawful to have a renewal in your fixed term contract, but if there's multiple renewals as of 6th of December 2023, that's considered as unlawful. So these restrictions apply to all fixed term contracts, including maximum term contracts, like I said before. And I think it's important to consider that there are other avenues outside of fixed term contracts, things like casual employment or part-time employment, to name a few. But like with any piece of legislation, there are some exceptions, and they're all listed here. I note that one of the main exceptions that might be relevant is exception 9, around being funded in whole or part of government funding, and describing that funding is directly related to the fixed term contract. There are some nuances, and I'm happy to talk about that offline if needed around that. So what should organisations do? as an employer, you need to review your current and future use of fixed term contracts, make sure that they comply with the new laws. You might need to adjust the length, the renewal options, or the termination clauses of your fixed term contracts. I think they're the main things that you need to think about, but also include, if you are going to proceed with a fixed term contract, to have the fixed term contract information statement that's been released by the Fair Work Ombudsman. Happy to, and the links are in there if required. If it's been distributed after this, Nina. Flexible work arrangements is another change. They were introduced back in 6th of June 2023. Flexible work arrangements have been around for quite a long time, but there has been some, I guess, nuanced changes around how flexible work arrangements are provided and requested. So I think the main things here is that you discuss a request with the employee, you make a genuine effort to find alternative arrangements, you consider the consequences of refusal for the employee, and you provide a written response, which includes an explanation as to why you've rejected it, and what you're willing to do to accommodate the request if the changes aren't accepted. The employee can also refer this on to the Fair Work Commission as well, if they don't agree with the business grounds, which is really important. So I want to talk about a case study in relation to flexible work arrangements. It's between Charles Gregory and Maxia Pty Ltd. This is Charles. He works for Maxia, who are a salary packaging advice and assistance organisation that provide that for employers. Mr. Gregory, his role requires him to provide advice and manage cases, and requires him to attend Maxia's premises to perform his duties. Mr. Gregory submitted a 100% work from home request through the Flexible Work Arrangements Act. And the reason for that is that he said that he had a health condition. So he had inflammatory bowel disease, and he had to look after his son. He wanted to work from home. Maxia has a hybrid work guidelines policy, and that policy says that he needs to work in the office at least 40% of the time, so around 2 days per week. The current Fair Work legislation in relation to flexible work arrangements talks about these requests, and some of these flexible work arrangement requests includes changes to the start and finish times, working from home or other locations. But in order for these types of requests to be accepted and satisfied, the employee must be able to point out at least one of the circumstances set out in what's called Section 65(1)(a) of the Fair Work Act, which relates to whether the employee is a parent or have a disability. In this case, Mr. Gregory is a parent, but also he alleges that he has a disability that would fit the threshold of the Fair Work Act. So there needs to be a connection, according to the Section 651A, between the Act and between the circumstances that he's described in his request. But also, he needs to fulfill a minimum employment period of 12 months of continuous employment, which he had. Also, he needs to have a request that's made in writing, and the request must set out a whole lot of changes, so the changes that he wants. And he set that out in writing, saying that he'd like to work from home 100% of the time. So I guess there are two questions. Does Charles have the right to work from home? And did Maxia, were they able to lawfully reject it? So the respondent in this case, Maxia, they did offer Mr. Gregory to work from home in the weeks that he was the primary caregiver of his child, and that was the flexibility that was being sought for the working hours, so allowing for his child to be collected from school. They also made some accommodations around his alleged disability, in that they provided a desk that was close to a toilet. The Fair Work Commission found that Maxia's reason for refusing the request but providing accommodations was lawful, that it was reasonable on business grounds. The Commission accepted that he had a condition, but they didn't say that it could be described as a disability as such, and the medical information that was provided by Mr. Gregory wasn't sufficient to demonstrate that. But also, they said that the accommodations that were provided by Maxia were good enough, and that the reasonable business grounds to reject it was satisfied. So the Commission didn't actually grant that flexible work request, which is really interesting, especially with work from home as being such a topical issue in recent times. So what should organisations do? They should review their flexible work policies, reflect that new process of providing the flexible work arrangements in writing, meeting with their employee, and being clear about the other accommodations outside of the request. And managers should also be trained to ensure that they spot a flexible work arrangement request and know how to respond to that properly as well. So the next thing that I'd like to talk about is monetary increases. This happens every year. With the annual wage review, the Fair Work Commission has increased the national minimum wage and award rates from to $882.80 per week and $23.23 per hour. So that's an increase of 5.75%. They've also increased super contributions as well. The rate has gone from 10.5% to 11%, and that all started on the 1st of July, and then there will be similar increases in the 1st of July 2024 this year as well. One of the other things that the Ombudsman is looking at and took Chai Time Australia to is that when we look at particular options provided to employees, in this case, the Chai Time CFO presented both options to the employees, but the director actually chose the cheaper option of the costing models when we were providing rates to employees. This was then referred on to the Fair Work Commission by the Ombudsman, and the Commission found that the lack of awareness or the director being unsure around the models and the significant changes between the costing models, it meant that the directors were personally liable to these fee changes. So I think what I'd like to say here is that when deciding on fee models and remuneration for employees and providing options, and you're making significant changes around those, that you look at the math around that, and that while the CFO and trusting the CFO on those types of things is the first action, but going through the detail and finding out whether your employees are better off or the models are quite similar is significant, because if those due diligence hasn't been provided, directors can be personally liable for those circumstances, which is really important. Parental leave, we've got the unpaid parental leave scheme, where from the 1st of July, employees can now take up to 100 days of 12-month unpaid parental leave entitlement flexibly, and pregnant employees can access their flexible leave entitlements up to 6 weeks before the expected date of birth of their child. And married employees or those that are in de facto relationships can take up to 8 weeks of unpaid parental leave separately or at the same time as well. So I think it's important there that eligible employees need to provide their employees at least 10 weeks written notice as well before starting any period of unpaid personal leave. And they need to set out how much leave they want to take and what those start dates and finish dates are as well. So what should organisations do? I think it's important to understand that the government paid leave parental scheme is separate to the unpaid parental leave scheme. Employees can use the parental leave pay before or after at the same time as their paid or unpaid leave entitlements. So that's annual leave, long service leave, unpaid parental leave. And while the government paid parental leave was introduced all the way back in the 1st of January 2011, this unpaid parental leave scheme was recent. So it's that combination of both, but they are very separate schemes, which can be generally confused by employers. What other changes? Organisations should review their parental leave policies, make sure that those changes are in place, and then if they need to look at the government paid parental leave scheme, that they should refer to the Service Australia website. There's a few other changes that have come in place, a bit smaller changes. One of the more important changes that a lot of employers miss is the pay secrecy clauses. So most standard employment contracts will have confidential information clauses within their contracts, but the pay secrecy clauses mean that employees can reveal their remuneration to other employees. What that means is that there should be an exclusion clause in your employment contract that says that the remuneration is excluded as confidential information. That's really important and often very missed by a lot of employers. There's also organisations' positive duty to eliminate workplace sex discrimination and harassment, and some compliance powers have been put in place by the Commission for the Commission in December 2023. There's some new changes flagged in Victoria around psychosocial hazards, and for employers that are above 100 employees, they have to report the gender pay gap, but also the age, workplace location, and the remuneration of the CEO, which is important. Other changes, there used to be an exemption for small businesses that were going to be insolvent or bankrupt to not pay redundancy payments. That's been removed. It means that any small business, employers that have less than 15 employees, if the business is going to become insolvent or bankrupt, they still need to pay the redundancy pay as well. The other thing that's important in this slide is the family and domestic violence is now a protected attribute. What that means is if employees disclose that they are subject to family and domestic violence, then they can't be disciplined due to that, which is important. Not that employers would generally do that, but it's now enshrined in law. So what's on the horizon? What's coming? One of the main things that has happened in recent times, and that there's a focus on underpayments. Focus on underpayments for big businesses. So you can see in the news, Uniqlo had $25 million of underpayments. Commonwealth Bank recently had a significant $10 million underpayment issue. I think Woolworths is about to cop an underpayment issue of $500 million. These are significant issues. So there has been a focus, but it's not just small businesses, but not just big businesses. The Ombudsman has now focused in their 2023-2024 priorities with these particular sectors. So agriculture, building construction, care, fast food restaurants and cafes, and then large corporates and universities, but also small business employers and vulnerable at-risk workers as well. It's just good to keep in mind that while the focus in the news are these big businesses, there is some focus for small businesses based on those sectors as well. So what should organisations do? They should regularly carry out audits to ensure that they at least meet the minimum rates for the national minimum wage and any applicable modern award rates or enterprise agreements. And that includes when employees are on annualised salaries, and they should look to see if their salaries and employment contracts are inclusive or exclusive of superannuation and paid accordingly. That's a no-brainer, but it's often missed. You'll be surprised. Right to disconnect. That has been quite significant in recent times. In last week, it's been a topical issue across every social media, everything online. And I think it's important because a lot of the time people might have jumped to conclusions about what that really is. So the right to disconnect legislation, well, it's passed in Parliament. What it does is that it prevents employers from disciplining employees if they don't monitor, respond, or to emails, telephone calls, or any other communication from employers outside of their working hours. So the key thing here is that it prevents employers from disciplining employees. It doesn't mean that employers can't contact employees outside of work hours. It just means that it can't be adversely affected. Employees can't be adversely affected. And it covers employees, but also third-party contacts. There's a lot of stakeholders that employees deal with on a regular basis. Those particular third-party contacts can't contact them, and there shouldn't be any discipline around that if that happens. That if employees ignore that contact. So similar to bullying and sexual harassment claims, if it is repetitive, if the employee feels that they are going to be disciplined, they can apply for a stop order, which involves the Fair Work Commission providing a decision for the employer or the third party to stop continuously contacting the employee for those issues and trying to adversely or injure their employment. So it hasn't come into play yet. It's been passed in the Parliament. Businesses will have 6 months to implement any changes, and small businesses, so employees that have less than 15 employees, will have 18 months, which is quite significant, long time, but it's important to get in play. So what should organisations do? They should review their position descriptions. They should look at their employment contracts. Might even consider having what's called an availability allowance, an out-of-hours allowance as part of their remuneration as well. And then train your managers. A lot of managers might feel like this new legislation would come into play means that they can't contact their employees outside of work hours, their scheduled hours. Doesn't mean that. So having adequate training around that, I think is really, really important. We've provided a sample policy on the Law Squared website that employees can download. Like I said, with the family and domestic violence policy, happy to tailor that for you if need be. Some other changes, the definition of casual employee has been changed. It also makes it easier for casuals to convert to permanent. And it also allows for the Fair Work Commission to set fair minimum standards for employee-like workers. So the gig economy, Uber drivers, also allows the Fair Work Commission to deal with disputes about unfair contract terms. So if you're engaging workers in independent contractor agreements, they now are covered under what's called the UCT regime, which means that there are terms in the contract that are significantly unfair, then legal action might be something that could be put forward against the business. So that's really important to understand. few other things as well. Industrial manslaughter is a new offence for the Work Health and Safety Act. This increased union delegate rights as well. So going on to the, I guess, potential risks and liabilities around that. Penalties are quite significant, 82,500 per breach for a corporation and 16,500 per breach for an individual. You might think, okay, does that mean the right to disconnect is covered under that as well? No, there won't be any fines that are attached to that. They are still trying to work through that. I think currently there is some sort of fines that are attached to it, but I think once it has its royal assent, there won't be any fines attached to that legislation. The other thing that outside of those penalties of reputational damage and loss of productivity and unhappy workforce, a lot of the time people miss that. They think about the penalties, but they don't really think about the reputational damage. And it'd be good for us to just kind of go into a bit of the, I guess, a case study around how reputational damage can be significant outside of the breaches and penalties of the Fair Work Act. And one of the case studies I'd like to speak about is Gene Madden and street swags. This case highlights, I guess, the intersecting issues of leadership disputes and the loss of donor confidence and the reputational damage when concerns are raised around the distribution of funds and donations. So the CEO founder of the Brisbane charity Street Swags, she was dismissed as an employee. In 2017, she was charged with criminal offences by the Queensland Police Force for dishonestly causing detriment to the charity. So there was 8 counts of fraud, which was around $154,000 worth of misappropriation of funds. And there was 1 count of falsification, destruction, alteration and damage of records. So the CEO made an application to the Fair Work Commission alleging that her dismissal was harsh, unjust and unreasonable. The criminal proceedings were on foot, which meant that the Fair Work Commission adjourned the actual proceedings until the criminal proceedings would be undergone. The criminal proceedings were actually later withdrawn, but in 2021, the Fair Work Commission decided that her dismissal was fair and reasonable in the circumstances, primarily because there was criminal proceedings on foot, and they did everything that they could to kind of engage with Miss Madden. And one of the counts they felt that was the failure to take legal advice around this resulted in the reputational damage. The CEO failed to take heed of the correct, I guess, sensible, firm legal advice that was provided by a pro bono firm around this. She actually stopped board members from actually contacting the lawyers around that. And there was a personal conflict as well. So she awarded a massive $528,000 contract to a de facto partner around this as well. So what's happened is you've got a situation where the board and its leadership aren't contacting each other, not resolving internal conflicts, while the Commission has decided that the dismissal was fair and not harsh. What's actually happened is that the donations to Street Swags was reduced by 30%, even if they had done everything correctly. So it's important to be vigilant around trying to resolve these types of matters before it does go to public proceedings, even if you've done everything correctly. Something that a lot of boards and management need to consider. Tips and tricks, strategic recommendations, make a plan. So we recommend carrying out an audit to ensure that your employees are earning at least the minimum wage, that you review your policies, so family and domestic violence leave, flexible work policies, review your contracts, ensure that there is that exclusion for pay secrecy, and and then carry out an audit for the fixed term contracts as well. Make sure if you are engaging in fixed term contracts, that you do have that information statement in there. And with mental health being such a massive issue in recent times, make sure that you think about having a psychosocial risk assessment and review that regularly. That's all I've got in terms of content. I'm happy to answer any questions. Go from there.
Thanks, Jess. Very clearly explained. So I know I really have appreciated that. Quite a few changes. I was writing a few notes, and I think the main takeaway for me is some of those last points, which was look up the changes and make sure that policies are updated. Yeah. So now we do have a question from Roma, and it was, it is, if you are exempt, do you still need to provide the information sheet to staff on fixed term contracts?
Yeah, you definitely do. So the exemption is around having contracts that are, have more than one option to renew, have the 2-year limit. So the exemption doesn't include the fixed term information statement. That should definitely be included. And it's similar to some of the stuff that the Ombudsman provided previously in contracts, where they have that Fair Work Commission statement, Fair Work Information Statement, where it talks about the rights employees have. So this is just, I guess, a flow on from that specifically for fixed term contracts.
Great, thank you. Do we have any other questions? Oh, yes, we do, from Bill. What would be considered a minimum standard for exercising positive duty to eliminate harassment?
Yeah, so a lot of the time employers feel that if they have policies in place, that is sufficient to kind of eliminate these types of risks. But what I would say is, along with policies, employees need to be trained on those policies. They need to acknowledge them on a regular basis. So I would say yearly, along with any new employees that are coming on board as part of their induction, they would include some sort of sexual harassment observers training. I think that's really, really important. And we've seen in the Commission, when these types of claims do go to the next stage, that the Commission member looks at those types of things. They'll look at not only the training, but what has the business done to ensure that all employees are working in a safe environment. And that is that every employee understands what is right and what is wrong in the workplace. A lot of that is commonplace, but there's always that grey. So having that in place, because one of the more important things for employers to consider is, while one of your employees might have committed the offence, employers are vicariously liable for the actions of their employees as well. So they need to demonstrate that they've done the training, that they have instituted training, and they do it on a regular basis across all their employees. Hopefully that answers your question, Bill.
Yes.
Sure.
Yep. So
Yeah.
thanks for that. And also, could you elaborate in the concept of protection in employment law?
Definitely. So if we look back at some of the things I was saying earlier in the stats, so general protections applications, every employee has what's called workplace rights. They have the right to make complaints and inquiries about their employment. They have the right to disconnect. They have the right to lodge a workers' compensation claim. They have the right to be protected for joining the union. The additional protection is this family and domestic violence notification. So they're protected by that. So having all these protections, what that means is that they can't be adversely affected if they exercise one of those workplace rights. If they are adversely affected, then the employee can lodge a general protections claim. And there's two different types of general protections claims, and hopefully I'm not going into too much of detail, but effectively, if you're currently employed, you can lodge a general protections claim saying that the employer has threatened my employment. And then there's a general protections claim that talks about I've been dismissed because I've exercised that workplace right. I've been dismissed because I've been subject to family and domestic violence. So having these types of laws is amazing for employees. It's unique for Australia. There are other countries that don't have that. I'm glad that we do. But it's very separate to an unfair dismissal claim that talks about valid reason and fair process.
Great, thank you. Are there any other questions, whether that's via the chat, or if you wanted to ask, you can unmute and or pop your hand up and nominate who has a question. Sue, yes, go for it.
Thank you. Jess, you spoke about audit, so auditing that people write contracts and that sort of stuff.
Definitely.
If they are completely internally conducted, so by our on-staff member review, is that, if all went badly, is that considered a suitable audit, or should some of these audits be done by an external person?
I don't think that there's any positive obligation to have an external audit. An internal audit outlining all that, all the things that I've outlined previously is sufficient. I think that's the main thing. If even after the audit there is some sort of misstep, what will happen is the employer generally will complain to the Fair Work Ombudsman. The Ombudsman would issue what's called a request for assistance, giving the employer the opportunity to respond to the allegations. And then the next step would be that they would issue a compliance notice outlining that these are the missteps, please rectify. It's when the Ombudsman, it's when the compliance notice gets ignored. Generally what will happen is the Ombudsman will take the employer to court, and it will have significant penalties. We're looking at $30,000 to $40,000 worth of penalties for an underpayment of maybe $1,000. So I think that's the most important thing. So when you keep in mind these things, do the audit as more of a due diligence. If there is a situation where the Ombudsman does issue some sort of notice, make sure you comply. That's all.
And follow up, sorry, Bill, I see your hands up, my apologies. So those internal audits, so that our board directors are protected or shown to be aware, that being part of their board paper pack would be sufficient?
That they're aware that the audits are happening. Is that right? Yeah. So I think having some sort of procedure in place, and for, say, if the board had an audit and risk committee, that they sufficiently contributed to kind of mitigating that risk would lend well. Definitely.
Thank you.
Thanks, Jess. And Bill, you've got your hand up. Go for it.
Yeah, thanks, Jess. This is a complicated. I'll give a setting first. Sometimes in the sector, often some providers might not be able to, or might have contracts that go for 48 weeks a year or 46 weeks a year that start in February and end in December. Because their funding does not allow them to pay, it's not viable for them to pay for 52 weeks, and there isn't work for people to do outside of the prescribed contractual non-teaching times. Sure. Is that, and then another contract would be signed in February, and there's now, are there any legal implications for about that practice that people should be aware of?
Just so I understand your question, Bill, so you're saying that there are circumstances where you've got a contract that is 48 weeks long, you've got a fixed term contract.
Yep.
Yeah, so I think that's lawful. But is it more around the new legislation around the fixed term arrangements?
Yeah, I was thinking about what the implications of the new legislation might be for that.
Yeah. So I think that that exception, and I don't want to give you specific legal advice just yet, but the idea with that particular exception is that the funding itself is bespoke, that it's specific to that particular contract, and that that it doesn't actually have any likelihood of renewing after that period of time. So if the fixed term contract is part of the core funding, then it's unlikely that it would cover under an exception. The funding would need to be specific around that particular fixed term contract, and the likelihood of it not being renewed is high. That answers your question.
Could I ask a follow-up question then?
Sure.
Yeah. Okay. So, but to say the contract with the funding authority and which funds the person's position is a 5-year contract, right?
Sure.
And so it's a guarantee of 5 years of income to fund the particular activity that the person is employed to do. Would that alter the situation, that factor, the fact that
it's 5 years? So the exception itself, it potentially would be captured under that exception, but I'd have to look into the detail to see around that advice and how that would look as for the fixed term contract. Sorry to be a typical lawyer.
No, it's fine, Jess. I understand entirely. Yeah, for sure.
Yeah.
Thanks. A good question there, Bill. I think it probably does, cross over our sector quite a lot, those fixed term contracts.
Yeah.
Yeah. Were there any other questions? Wait a minute. That's been some great information, I have to say. I really liked the 2 examples, Jess, as well. They were really clear. And I really appreciate that. I've been in, as many people here, lots of different legislation change, webinars, and sometimes I click out and I'm more confused than when I clicked in.
Yeah, definitely.
Yeah, but this has been really clear, so I really appreciate that, and your presentation and the slides they were great. So it'd be really interesting, I think, to see into the not too distant future how that right to disconnect plays out. And I can see that there might be a possibility of ACEVic doing a little bit of training there for some managers. So so in this executive exchange space. So thank you for that. Were there any other comments? So I've just got in the chat there from Laura. Bill, check the exemption 8 award provision. Higher education is listed as it may be included. So thank you for that. As always, these executive exchanges are bringing a wealth of knowledge from providers, and providers coming in with all different job descriptions and job titles. So any little bit of advice builds on the sector's knowledge, which is great. So thank you. All right. Well, if there are no other questions, I can give you 8 minutes of your noon to 1 o'clock time back. So once again, Jess, I just really wanted to extend our thanks for your presentation. Like I said, really clear and really poignant for our sector to get on top of it, early in the year. So I really appreciate your time today.
Yeah, definitely. And if anyone does want to give me a call or drop me an email or connect with me on LinkedIn, I'm more than happy to do that as well. But really appreciate the time and for everyone attending.
Great. Thanks so much. Enjoy the rest of your day, everybody.
Thanks, everyone.